Imagine this, a text message, a swerving car, and suddenly your world changes. You're hurt, your car is totaled, and the other driver, they're just sorry. But is sorry enough when your future is at stake? Today, we're diving into the often overlooked legal strategies that can empower you after a distracted driving crash. Let's start with the very beginning, the accident scene itself. The first priority is safety. Move to a safe location if you can and check yourself and others for injuries. Once you're safe, gather critical information. Exchange insurance details, but don't stop there. Take photos and videos of everything: vehicle damage, road conditions, skid marks, and even the surrounding area. If you notice the other driver holding or dropping their phone, or if witnesses saw them texting, capture that detail. Finally, report the crash to the police. Make sure the officer includes distracted driving in the report if you suspect it played a role. That single detail can be extremely valuable later. After the scene is cleared, your focus should shift to the evidence. This is where many injury claims are won and lost. You need to document everything. Keep a journal of your injuries, doctor visits, physical therapy, and even the small daily struggles like missing work, not being able to pick up your child, or losing sleep because of pain. Witnesses are also powerful. Make sure at the scene to get names and contact information from anyone who saw what happened. Even a short statement about the other driver's behavior can help confirm a distracted driving case. And don't forget about electronic evidence. Dash cam footage, surveillance video, or even the driver's phone records can show exactly what caused the crash. Preserving this evidence early makes all the difference. Next, you need to understand your legal rights. Distracted driving laws can vary from state to state. In some places, texting is the focus, while others include eating, grooming, or using in-car screens. Here in Georgia, we have what's called the Hands-Free Georgia Act. That means drivers cannot hold a phone, they can't text, they can't even watch a video while behind the wheel. Calls are only allowed if you're using Bluetooth or another hands-free system. If someone violates this law and they cause a crash, that violation can be powerful evidence in your injury claim. It shows the other driver wasn't just careless, they also broke Georgia law. But here's something many people don't realize. Georgia follows what's called modified comparative negligence. If you were less than 50% at fault, you can still recover damages, but your recovery is reduced by your percentage of fault. For example, if your damages are $100,000, but you're found 20% responsible, you'll recover $80,000. If you're 50% at fault or more, you can't recover anything under Georgia law. That's why documenting distracted driving is so critical. It can make the difference between a strong claim and no recovery at all. Now, then comes the decision every injured person faces. Do you settle or do you go to litigation? Some cases can be resolved through negotiation, but others require preparation for court to secure fair compensation. So this is often the most frustrating part. Insurance companies are businesses. Their goal is to pay you as little as possible. When speaking with adjusters, you have to be careful. Don't admit fault. Don't overshare details about your injuries before you know the full extent. Insurance adjusters love to give you a phone call within 2 to 3 weeks of your accident because at that point you don't know the severity of your injuries and you know that, hey, I can walk. I can do things still. I'm still in a little bit of pain, but I think it's going to go away. And they will use that against you and your lack of experience, knowing that these injuries often linger for quite a long time, and offer you a lowball offer and try to get this done as quickly as possible. One important thing attorneys do is get the policy limits, both yours and the at-fault drivers, so you understand how much coverage is available in your case. Watch out for lowball settlement offers. Insurers try to close your claim quickly for far less than you'll need to cover your medical bills, your lost wages, and long-term care. So when should you involve an attorney? The earlier, the better. Having a lawyer on your side can help preserve evidence, manage communication with insurers, and ensure deadlines are met. You want to look for an attorney that has real experience in personal injury and distracted driving cases. They'll understand the nuances of these claims and know how to challenge the insurance tactics. Most importantly, an experienced attorney will help you maximize your compensation by accounting for all recoverable damages, not just your medical bills, but also your lost income, your pain and suffering, and your future medical care. Distracted driving crashes change lives in an instant, but you don't have to navigate the aftermath alone. With the right steps, the right evidence, and the right guidance, you can protect your health, your rights, and your future. If you found this helpful, check out our other videos on proving distracted driving after a crash. It's linked here in the description. Stay safe, and I'll see you in the next video.